Every single year in the United Kingdom, thousands of renters lose hundreds or even thousands of pounds of their deposit money completely unnecessarily. And the most devastating part is that landlords are counting on you not knowing the rules because ignorance is what makes the deposit trap work. If you have ever lost money from a deposit, or if you are renting right now and have a deposit sitting with your landlord, watch this entire video. Because by the time this video ends, you will know exactly how the deposit trap works and exactly how to make sure you never fall into it again. Let me start with a number that should make every renter in England absolutely furious when they hear it for the very first time today. Research consistently shows that UK renters lose an estimated hundreds of millions of pounds every single year through unfair or illegal deposit deductions from landlords. Money that was legally theirs to keep money that their landlord had absolutely no right to deduct, money that disappeared simply because nobody told them the rules. This video is going to change that right now, and I need you to share it with every renter you know when this video is finished today. Let us start with the most important thing every renter in England needs to know about their deposit, and that is the deposit protection rules. The moment your landlord receives your deposit money, they have exactly 30 calendar days to protect it in a government-approved tenancy deposit protection scheme. Not 30 working days, not 30 business days, 30 actual calendar days starting from the very first day they received your money in their hands. There are 3 government-approved schemes in England where your landlord must legally register your deposit money: the Deposit Protection Service, My Deposits, or the Tenancy Deposit Scheme. Within that same 30-day window, your landlord must also give you something called the prescribed information about your deposit protection scheme. This prescribed information must include the full name of the scheme holding your money, the amount of deposit protected, the full contact details of the scheme itself. It must also explain exactly what circumstances might justify deductions from your deposit, and it must tell you how to get your money back at the end. If your landlord fails to protect your deposit within 30 days or fails to give you the prescribed information, they are breaking the law immediately. And here is where the deposit trap gets really serious, because the penalties for failing to protect your deposit are genuinely enormous for landlords right now. If your landlord did not protect your deposit correctly, you can apply to the county court and claim compensation of between 1 and 3 times the full deposit amount. That means if your deposit was £1,000 and your landlord failed to protect it, you could be entitled to claim up to £3,000 in compensation. If your deposit was £2,000 and protection rules were broken, you could potentially claim up to £6,000 in compensation through the county court today. And crucially, your landlord also faces civil penalties from your local council of up to £7,000 for a first breach and £40,000 for repeat offenses. So the very first thing I need you to do right now today is check whether your deposit has actually been protected in one of the 3 approved schemes. You can check this completely for free by going directly to the websites of the Deposit Protection Service, My Deposits, or the Tenancy Deposit Scheme right now. Each of these 3 schemes has a completely free deposit lookup tool where you search using your surname, your property postcode, and your tenancy start date. If you search all 3 schemes and your deposit does not appear in any of them, your landlord may not have protected it, and you may have a legal claim. Now let us talk about the deposit cap, because this is another area where landlords have been taking money from renters that they had absolutely no legal right to take. Since the Tenant Fees Act 2019 came into force, the maximum deposit a landlord can legally charge you in England is 5 weeks' rent for most tenancies. If your annual rent is below £50,000 per year, your landlord can only charge you a maximum of 5 weeks' rent as a tenancy deposit today. If your annual rent is above £50,000 per year, the maximum increases slightly to 6 weeks' rent, but it cannot go beyond that absolute limit. If your landlord charged you a deposit that exceeds 5 weeks' rent when you moved in, that excess amount was a prohibited payment and you can claim it back. Many renters who moved in several years ago were charged deposits well above this 5-week cap limit and have never been told they can reclaim the difference. Check your original tenancy agreement now and calculate whether the deposit you paid exceeded 5 weeks of your monthly rent when you first moved in today. If it did exceed the 5-week cap, contact Citizens Advice immediately, because you may be entitled to have that excess amount returned to you right now. Now let us move to the part of the deposit trap that catches the most renters completely off guard and costs the most money when they move out finally. This is the deductions trap, and it is where landlords make their most significant amount of money from renters who simply do not know how to fight back effectively. When your tenancy ends, your landlord can only make deductions from your deposit for very specific reasons that are recognized and limited by law in England. They can deduct for unpaid rent that you genuinely owe, for damage to the property that goes beyond what is called fair wear and tear, and for cleaning. but they can only deduct for cleaning if the property is left in a genuinely worse condition than it was when you moved in at the very start. And they can only deduct for items listed in the original inventory that are now missing from the property when you hand back your keys at the end. What your landlord absolutely cannot deduct for is something called fair wear and tear, and this is the rule that landlords hope you will never properly understand. Fair wear and tear is the completely normal and completely inevitable gradual deterioration that happens to any property through ordinary everyday use over time. Carpets that are slightly worn after years of normal use, paintwork that has faded naturally, small scuffs on walls from normal furniture placement. These are all fair wear and tear. Your landlord cannot charge you a single penny for fair wear and tear, and if they try to deduct for it, they are making an unlawful deduction today. The problem is that many renters do not push back on these deductions because they do not know this rule exists, and landlords count on that ignorance completely. So here's what you need to do right now if you are currently renting to protect yourself from the deductions trap when your tenancy eventually ends one day. When you first move into a rented property, take detailed photographs and videos of every single room, every wall, every floor, every appliance, every piece of furniture. Document the condition of absolutely everything on the day you move in, and make sure every photograph and video has a clear date and timestamp on it. If your landlord or letting agent provides a check-in inventory, sign it only after you have carefully checked it against your photos and corrected any inaccuracies you find. Add your own notes to the inventory if anything is wrong, missing, or already damaged before you move in, because that record is your protection at the end. Email your landlord on the day you move in with a clear summary of any issues you found with the condition of the property on that very first day. Keep that email chain and keep copies of every communication you ever have with your landlord about the condition of the property throughout your entire tenancy. When you leave the property, take exactly the same detailed photographs and videos of every single room to document the condition you are leaving it in on departure. Get a professional clean done before you leave and keep the receipt, because a cleaning receipt is powerful evidence if your landlord tries to charge you for cleaning costs. If your landlord proposes deposit deductions that you believe are unfair or are unlawful, do not simply accept them and walk away, because you have the right to dispute them. Every government-approved deposit protection scheme offers a completely free independent dispute resolution service specifically for exactly this kind of deposit dispute situation. You do not need a solicitor, you do not need to go to court, and you do not need to pay anything to use the scheme's dispute resolution service today. You simply submit your evidence, your move-in photos, your move-out photos, your cleaning receipt, your email communications, and an independent adjudicator reviews everything. The adjudicator will make a binding decision about how the deposit should be divided between you and your landlord based purely on the documentary evidence provided. Adjudication decisions are legally binding on both parties, and the entire process typically takes around 28 days after both parties submit their evidence completely. Here is something critically important about how the adjudication process actually works that most renters do not realize until it is already too late for them. The adjudicator decides the case based entirely on the documentary evidence submitted, and nothing else matters to them in making their binding decision about your deposit. This means that a landlord who claims your carpet was damaged will only win if they have dated photographic evidence proving the carpet was in good condition when you moved in. If your landlord cannot produce a proper check-in inventory with photographs showing the condition of the carpet on move-in day, their deduction claim will almost certainly fail completely. And if you have your own move-in photographs showing the carpet was already worn when you arrived, your landlord has absolutely no chance of winning that deduction claim. Evidence wins deposit disputes, and the renter who wins is almost always the renter who took comprehensive photographs and kept meticulous records throughout their entire tenancy. Now, here is something else that many renters do not know, and landlords absolutely do not want you to find out about your deposit rights under the new law. Under the Renters' Rights Act 2025, a landlord who has not correctly protected your deposit and given you the prescribed information cannot pursue a possession claim against you. This is an extraordinary and powerful protection that links your deposit rights directly to your right to stay in your home under the new law today. If your landlord wants to use any Section 8 ground to end your tenancy, they cannot do so if they have not first correctly protected your deposit and provided prescribed information. This means a landlord with a deposit protection failure must first fix that failure before they can even begin the process of asking you to leave your home. And while they are fixing that failure, they will have already triggered the financial penalty process that could cost them between 1 and 3 times your full deposit amount. Now, let me give you your complete action plan based on everything you have heard in this video, because knowledge without action will not protect your money at all. Step 1. Check right now whether your deposit is protected by searching the DPS, My Deposits, and TDS websites using your postcode and tenancy start date today. Step 2. Check whether the deposit amount protected matches exactly the amount you actually paid, because any discrepancy is itself a serious compliance issue. Step 3. Check whether your landlord gave you the prescribed information within 30 days of receiving your deposit, and if they did not, you have a legal claim. Step 4. If you are currently in a tenancy, take comprehensive dated photographs of every room and every item in the property right now today without waiting. Step 5. If your landlord proposes deductions when your tenancy ends, dispute any deductions you believe are unfair using the free scheme dispute resolution service immediately. Step 6. If your deposit was above the 5-week cap when you moved in, contact Citizens Advice today about recovering the excess amount that was taken from you. Step 7. If your landlord never protected your deposit at all, contact Citizens Advice and Shelter immediately, because you may have a court claim worth 1 to 3 times your deposit. Citizens Advice at citizensadvice.org, UK, and Shelter at shelter.org, UK. Both offer completely free expert guidance for renters dealing with deposit protection problems right now today. The Deposit Protection Service at depositprotection.com, My Deposits at mydeposits.co, UK, and TDS at Tenancy Deposit Scheme.com all have free deposit lookup tools available right now. The Gov. UK website contains official guidance on tenancy deposit protection rights at Gov. UK, and you should use it as your primary official reference for all deposit information. Your deposit is your money, and your landlord holds it as security, not as a bonus payment, and they must return every single penny they cannot lawfully justify keeping. Do not let your landlord keep money they are not legally entitled to keep, because the free dispute resolution system exists specifically to prevent exactly that from happening. Share this video right now with every renter you know, because most people renting in England have no idea about these deposit protection rules and are vulnerable to the trap. Your family members who rent, your friends who rent, your colleagues and neighbors, every one of them needs to know these rules before they next hand over their deposit. If you found this video helpful, please like it right now, because it genuinely helps thousands more renters find this information before they fall into the deposit trap themselves. Subscribe to UK Housing Alert and hit the notification bell so you never miss an important housing law update that could protect your home and your money every week. We cover housing law, tenant rights, landlord rules, deposit protection, and benefit changes every single week in plain, simple English, so you always know exactly where you stand. Your deposit is protected by law, your rights are real and enforceable, and no landlord in England can legally take money from you that they are not entitled to keep. UK Housing Alert is here every single week, making sure every renter in England knows exactly how to protect their money and enforce their full legal rights today always. Many renters do not realize they can check their deposit protection status at any point during their tenancy, not just when it ends, so check yours right now today. If you discover mid-tenancy that your deposit was never protected, you can take legal action immediately without waiting until your tenancy ends to do anything about it. The 6-year limitation period for bringing a deposit protection penalty claim means that even if your tenancy ended years ago, you may still be able to claim compensation. If you moved out within the last 6 years, and your landlord never protected your deposit properly, you should contact Citizens Advice immediately about making a late claim. Renters who used a letting agent should know that the agent and the landlord share responsibility for protecting the deposit, and both can face penalties for non-compliance. If your letting agent failed to protect your deposit, even if your landlord believed the agent had done it, the renter can still pursue compensation from both parties involved. Always ask for written confirmation of which deposit scheme your money is in when you pay your deposit, and keep that confirmation somewhere safe throughout your tenancy. If your landlord or agent cannot immediately tell you which scheme holds your deposit, that is itself a serious warning sign that something may have gone wrong already. Renters in houses in multiple occupation or HMO properties should be especially vigilant about deposit protection, because these properties have historically had higher rates of non-compliance. If you live in a shared house or HMO, check all 3 deposit protection scheme websites right now, because your deposit is just as protected by law as any other tenancy. When disputing deductions at the end of a tenancy, always submit your evidence to the scheme dispute service within the time frame stated in your prescribed information document. Missing the dispute deadline can result in you losing your right to use the free adjudication service, so always act promptly when deductions are proposed by your landlord. If your landlord proposes deductions, but does not provide any evidence, such as photographs or contractor quotes, challenge them immediately in writing and request their full evidence. A landlord who cannot provide photographic evidence of the condition of the property at check-in will almost certainly lose any deduction dispute before an adjudicator completely. The adjudicator will only award deductions that are supported by clear documentary evidence and proportionate to the actual loss the landlord has genuinely suffered from damage. Betterment is another important rule that renters should know, because a landlord cannot charge you the full cost of replacing a carpet that was already 5 years old. If an item was already old or worn when you moved in and it needs replacing, the landlord can only claim a proportionate contribution, not the full replacement cost from you. The deposit dispute system in England is one of the most renter-friendly legal mechanisms that exists, and most renters never use it simply because they did not know it was there. Use this system, document everything, know your rights, and never let your landlord take money from you that they are not legally and evidentially entitled to keep from you. Subscribe to UK Housing Alert right now and hit the bell, because every week we bring you the housing law knowledge that protects your money and your home.